This comment says, my mom and I own a house together. The tenancy isn't specified, so I know it's tenants in common. My question is, what would happen if my mom passed? So the whole tenants in common versus joint tenants, I'm only speaking with respect to Florida law. So if you live in another state or this deed is done in another state, I can't comment, and I honestly don't know the answer as to how that state would handle it. So I will give you Florida with the assumption that this is a Florida property. Anytime someone acquires property with one or more other people, and that is not their spouse, then in Florida, it defaults to tenants in common. And I think you knew that based on your question. So then the question becomes, if we know we have a tenants in common situation and one of the owners dies, whether there's 2 owners or 20 owners, what happens to the deceased owner's share? The answer is it would need to go through their probate estate, and that share will then go out, whether they have a will or through intestacy. If they don't have a will, it will go to their heirs. That gets really tricky when it comes to real property, because a lot of times you may not want to have a joint owner with someone who you originally didn't agree to own the property with. It's kind of like owning a business, and then one of the business partners dies, and then like their spouse or their children just show up one day and say like, hi, I own the other half of the business. Like, let's get to work, partner. And you're like, but I didn't want you as a partner. So you may not want to own something with someone because, as I always say, they could move into it, not pay any expenses, and then tell you like, what are you going to do about it? I'm an owner. And that's not a scenario that you want to run into with real property or business ownership, or quite honestly, anything else in your life. So the answer is it would have to go through probate, and it'll spit out wherever probate spits it out as far as who the owner is. But if you were an only child and you owned it with your mom, then yeah, it would actually go to you, but still have to go through probate to get to you. So not a great solution. In tenants in common, what mom could do, or anybody could do in that situation, is take their piece of the ownership and put it into their revocable or irrevocable trust to avoid probate when they pass, and they can determine who the beneficiaries are. If your intent was to buy the property jointly and have that rights of survivorship, you can always redraft the deed, and it would be from you and mom as tenants in common to you and mom as joint tenants with rights of survivorship, and then that would automatically give the beneficiary to the surviving owner. I hope this helps. Have a great day.